Hi, welcome to the second part of this webinar about new media in the courts. In the first part, we discussed the findings from the Conference of Court Public Information Officers study that we did last year. And I'm going to touch on some of the other material that's in this study in this second part of the webinar. And I would invite you to, if you haven't already, download the report, which you can get at ccpionewmedia.ning.com. Also at that website, there's a lot of other information and resources about the topics that we are going to discuss today and that we discussed in the first part of this webinar. Before we get started, I wanted to talk a little bit about that project and recognize the two other individuals who helped with this research. The Conference of Court Public Information Officers decided in 2009 to launch a study about new media in the courts. We created the website that I cited, ccpionewmedia.ning.com, as an online community to share information and stories and resources about what's going on in the court community nationally in the area of new media. Also involved in the project were my colleague Karen Salez with the 19th Judicial District in Colorado and Dr. Thomas Hodson of the Scripps School of Journalism at Ohio University. The reason that we decided to take a close look at new media in the courts is because it's affecting court operations at many different levels. The judicial community for the past couple of years has gotten more and more involved nationally in taking a look at new media, and so CCPIO decided it was something that really needed to have a study devoted exclusively to it. And we spent about a year studying new media, and we started out by defining the term new media. And you can see in this slide that we defined it as including really three main components. First off is that new media involves interactive social media technologies that are multimedia in nature. These are technologies like what's often called the big three, Twitter, Facebook, and YouTube, but also countless other different websites and technologies out there that together are creating this multimedia environment that courts are operating within, that really the whole culture is operating within. Second piece, though, is something that often gets overlooked but is really critical for courts if we want to support public trust and confidence in the court system. Over the last several years, we've witnessed really dramatic changes in the traditional news media that courts for over 2 centuries have relied on as really a partner, sometimes a difficult partnership, and nonetheless an interesting partnership between courts and the traditional media, newspapers, magazines, television, radio. Just in the last several years, though, the traditional media has experienced significant changes. There have been declines in circulation, declines in viewership, and resulting declines in revenue, and bottom line is there's fewer reporters covering the courthouses. And we used to have judges, I'm sure you've had your judges that have complained about those pesky reporters asking those difficult questions and causing potential problems in administering trials, and et cetera. But now we have judges saying, what happened to the reporters? And we have judges expressing real concern about how we can explain what we do in the judicial branch when there are fewer and fewer reporters who are covering the courts. So that's the second piece of this new media environment that CCPIO set out to study, taking a look at these changes in the traditional news media and the implications that they have for the courts. And the third is really a product of the first two. Because you have more and more people getting news and information from a variety of different sources, because of the rise of Facebook and YouTube and Twitter and all the rest, because of the corresponding decline in the traditional news media, taken together, this has resulted in broad changes in the way that the culture really processes information and understands the world. People have different expectations about how they're going to connect with courts, and this is changing, continuing to change as we move forward. So it's something that we will need to keep an eye on for some time. But these three things taken together, the explosion of social media technologies, the decline in the traditional news media, and the resulting broader cultural changes in how the public expects to receive information, how the public understands the world, we identified as the new media, and have taken a look at what it means for the courts, which we're going to talk about more in today's presentation. In the first session, and again, I see that a number of you weren't at the first session. In the first session, we got into quite a bit of detail on some of the findings of our report. We don't have time to do that today. I would invite you to visit the site and take a look at that. And as Margaret said, the actual video of the initial presentation is available as well. So I'm going to sort of skip ahead and not talk about some of the specifics of the report and get into what we're seeing out there right now in terms of courts proactively going out and using new media. Before I do that, though, I would note one of the things that we discussed in the first session and was a finding of the report, which is that one of the fundamental things that we found, and when I say we found it, this isn't anecdotal, this is semi-scientific, I guess you could say, because the biggest piece of the research that we did in the report was a national public opinion survey that we administered through the National Center for State Courts of judges and court administrators around the country that reached over 15,000 judges and court administrators and had a pretty strong response rate. And one of the things that we found is that at least as of August 2010, it's really a very small number of courts at that point in time who had stepped out into using new media or social media proactively. Less than about 7% of courts indicated that they had some type of presence on Facebook, and the numbers dropped even farther when you were talking about Twitter and YouTube and things like that, blogs and all the rest. So it's a very small number of courts as institutions as of right now that have branched out into this, but it's interesting to take a look at some of the examples of courts that have ventured into this territory. And here's an example here on this slide, a judge from here in Ohio, actually at the Medina County Courthouse, Judge James Kimbler, who has this blog where he writes pretty candidly about what goes on at the courthouse there, what's gone on in his courtroom that day, different cases, and that sort of thing. A little bit later, we're going to talk about some of the concerns that this raises that judges and court officials need to be aware of if they're going to go out into this territory. But for now, it's just interesting and noteworthy to see that there are some brave souls who are venturing here, and this is just one example, which again, if you go download this this presentation, you'll be able to click on this and kind of explore these sites, which I would encourage you to do because there's some interesting stuff out there. Here's an example of a practice that's becoming more common, which is courts venturing onto Facebook, which is by far the most popular social media site in the general population, as well as the most widely used among judges. Now, I said that our survey found that less than 10% of courts are on Facebook and YouTube and other social media sites, but judges as individuals, not necessarily as judges or as their courts as entities, judges and as individuals reported on our survey a rate of about 40% on Facebook. The majority of those indicating that they use Facebook in more of a personal capacity. And some of the judges I've talked to, and I'm sure many of you who are on Facebook pursue a similar practice, which is to try and isolate your personal from your professional life, and that's what we're seeing a lot of judges doing. And there's a whole wide array of settings that are available on Facebook to adjust your privacy and adjust the level of access that people have. But about 40% of judges in our survey indicated that they use Facebook in some capacity, and interestingly, that tracked almost perfectly with the general population, about 40% according to the Pew Centers. Here's an example of not a judge, but a court as an actual entity on Facebook, which, as I said, is around 7% of courts reporting that they've done this, and we would expect that number to maybe grow. It's the Maricopa County Court in Arizona, which was one of the very first to get on Facebook just a couple years ago. And you can see that, well, I hope you can see, actually. It's a little hard to see, but you can see that they really are posting things on here that are very just factual and informational, and the type of information that you might see posted or displayed or shared elsewhere, which makes a lot of sense if you think about it, and is by far the most common practice, if not really the exclusive practice among courts that are using social media. What you see is courts taking information that is already prepared, has already been prepared for some time for other purposes, for public purposes, and that they may have been making available on their website, or that there is some demonstrated public need for, and already has a system in place for vetting to make sure that it's accurate and that it doesn't pose any problems and isn't a violation of privacy and all the rest of the things we need to be concerned with public communication as a court. And then they're using Facebook and sometimes Twitter and other social media sites as really just another means of dissemination of this information that they've determined they want to get out anyways. It's a really safe way to branch out into social media. And it dispels the common misconception that you hear out there that, well, geez, I don't care about Facebook or Twitter because I don't care what Joe Smith had for lunch, right? In fact, you often hear that charge leveled against Twitter for some reason. I think part of that has to do with the way that the name itself kind of is frivolous. Twitter just kind of sounds kind of like, I don't know, not something that has a lot of gravitas. And so people have this misconception about Twitter that also I think applies to a lot of other social media sites, that is frivolous, and that the information there is what Joe had for lunch or for breakfast. And certainly if any of you are on Twitter or Facebook, there are people posting things that are less than frivolous. But you can see from this usage here in Maricopa County and some of the other stuff I'm going to show you, courts, being the conservative institutions that they are, and being concerned as they are with public trust and confidence, are venturing into, those courts that are venturing into this territory are doing so very carefully, and they're sharing information that they would be sharing through other channels anyways, which is a pretty sound practice. It makes a lot of sense. One of the interesting, and this here is a Twitter page that I included because I wanted to invite any of you, not just Twitter users, you wouldn't have to be a Twitter user to do this, to check out this page by clicking on the link when you download the presentation. This is one of the interesting things about Twitter, is that it creates the ability to create lists, and there are thousands of people out there that are doing this on their own. They're creating lists that aggregate Twitter feeds on a particular topic, and this is a list that was created by I think it was somebody with the National Center for State Courts in association with their court technology conference, that just all it does is it aggregates Twitter feeds that are either from courts or about courts or might be of interest to courts. And if you visit this, and again, you don't have to be a Twitter user to do this, because Twitter is an open source website that you can view without being a member. You only have to be a member on Twitter if you want to send tweets and participate more fully in the interactive nature of it. And if you visit this, you'll see that there's a lot of interesting information that's being aggregated there. And one of the most powerful things about Twitter is these links. You can see in that first one, there's a tweet from a Fulton County, the Fulton County Court, which I believe is Atlanta. Can one of my Georgia people give me a shout out with a hand up? Tell me if I'm right or wrong about that. I believe Fulton County is Georgia. And okay, yes, thank you. The PIO for the Fulton County Courts just says, look, here's an interesting article. And there's the link to it. And you can just click on that link, and it'll take you to the article. And this is the way a lot of people are getting their news now, through Twitter and Facebook and other sources. And Tom Hodson, who I mentioned earlier at the Scripps School of Journalism, has a saying for this, which is becoming pretty widespread idea in the journalism community, which is people no longer find the news or seek the news finds us. And what they mean by that is people are on Twitter, they're on Facebook, they're linked in with communities of like-minded people, and throughout the day they're being exposed to links like what you see here on this Twitter feed, and that news is finding them. People don't go to the New York Times webpage anymore to read the New York Times per se. New York Times articles find them through Twitter and other sources like this. This Twitter page is an example of what I mentioned earlier, that whether courts are ready to willingly get involved in social media themselves or not, social media is going to find you. And under this example, this is a reporter for the Akron Beacon Journal, and what this also shows is the way the traditional media is fully embracing Facebook and Twitter and these other sources, because they recognize that it is a main conduit for their news now, and so they're proactively experimenting with how to use it. This affects courts in a number of ways, and one of them is that reporters are it's becoming almost routine now for reporters to want to sit in trials and cover them in real time by tweeting what goes on there. And this Phil Trexler from the Akron Beacon Journal in Ohio is a reporter who has done that pretty successfully. And if you visit this page, you'll see that there are several high-profile trials that he has covered that way, and it just sort of changes the whole dynamic of covering a trial for journalists, but also changes the dynamic of following a trial if you're just a consumer of the news, and it raises implications for the courts. One example of that, which you can read about on our website, is it affects the federal courts more, and other state courts that have bans on broadcasting, quote unquote. Of course, everyone knows that the federal courts have had a long-standing ban on broadcasting federal court proceedings, and there's an open question at this point as to whether tweeting from a federal courtroom would constitute broadcasting. There was one case of a federal judge in Georgia who was faced with this question and an objection from defense counsel to a request by a member of the news media who wanted to tweet the trial in real time. And the judge researched it in response to that motion to not allow this, and wrote a really thoughtful 5 or 6 page entry examining the First Amendment implications, examining the history of the rule banning broadcasts of federal proceedings, examining what Twitter even is, and concluding that it is broadcast, and on that basis denying the reporter's request to do that. There's a copy of that motion available on our website if you're interested in reading about it, and there have been other judges who have not issued written entries as this judge did, getting into the reasoning behind it, but there have been other judges in federal courts that the media have reported have actually allowed it. So the federal courts don't have a uniform rule at this point nationwide on the question of whether tweeting constitutes quote-unquote broadcast. But you can see here just one of hundreds of examples out there, and I'm sure some of you may have encountered this in your own courts, where it's becoming a pretty widespread practice for members of the media to have the expectation that they will be able to do this, and some of them have done it pretty effectively. Other news outlets, traditional news outlets, are branching out into new media even more extensively in their coverage of high-profile trials by creating blogs that are dedicated really exclusively to that particular high-profile trial. This one here being an example of the Stephen Spader trial. and you can see that it has the quality of a blog in terms of just a running commentary. This reporter also had a Twitter feed. The term that often gets used for this in journalism circles is convergence. The idea that news outlets are starting to converge various forms of coverage, various types of media, and try and deliver news and cover news in a way that brings all these together. And this is a good example of it, because you've got a blog, the fellow has a Twitter feed, they're posting video. In fact, in this case, it's live video, which this particular jurisdiction obviously allows for and others wouldn't. But the idea is you can expect increasingly to see the traditional news media come to your courtrooms with the expectation that they're going to have greater access and the ability to use these multimedia tools, these social media tools, for broader real-time coverage of trials, particularly high-profile trials, but not just high-profile trials. The technology is allowing for sort of niche coverage of even lower-level trials, and you can expect to see that increase moving forward. This somewhat confusing looking slide is of something called TweetDeck. Is there anybody out there who's familiar with or uses TweetDeck? If there is, maybe give me a thumbs up or a hand up or something. Nobody? I would suggest that you take a look at this if you have an interest in new media. In fact, I would strongly suggest it, because TweetDeck is a free software download that's very easy to install on your computer. And what it allows you to do is, Margaret, if I want to point to these, what do I want to use? Do I just want to point to these different columns here? Do I have a tool here that's a pointer tool? This here? Is that it? Are you seeing it? Points to items of interest on the screen, it says. There? Oh, okay, got it. Okay, so you see these 4 columns. These are 4 different feeds for, the first one is a Twitter feed. The second one is a Facebook feed. The third one is a LinkedIn feed. And the fourth one is yet another Twitter feed for another account. And it's really almost unlimited what you can do with this in terms of adding feeds. In fact, you can go up to this little button here and press on it to add a column. And in using that column, you can create another column that would be based on a search term. So you can actually create one of these columns and type in the search term, say, Supreme Court of Ohio, and anything in what's now somewhat cutely referred to as the Twitterverse will show up in there. And I've used this extensively to monitor news and discussion about various topics like our court by creating these columns. And in real time, you will watch things appear. And you can monitor as I said, multiple feeds, your Twitter feed, your Facebook feed, etc., all from one source. So this is a really interesting, easy-to-use tool to start to explore this social media stuff in greater detail. And when you do that, which again I really would encourage you to do, it's fascinating to play around with and very easy. What will end up happening is you will be struck by the idea that all of this stuff is converging, and there are real-time conversations going on out there in cyberspace about your court. You will find about things going on at your court, about trials, about your judges. Hopefully not your judges, because when people talk about judges, it's usually bad in this type of context. But you'll find that this helps you get a handle on the fact that when we talk about social media, it's not just Facebook over here and Twitter over here, and I have to go to just 2-3 years ago, the way it worked was if I wanted to do Twitter, now I have to go to the Twitter site on my laptop or my desktop, and I have to explore, take a look at Twitter. And now I'm going to go to Facebook, and I'm going to take a look at Facebook. This stuff is converging because of applications like this TweetDeck, and there are other ones out there. There's a web-based one that's called Hootsuite, which I don't use. I find it a little more cumbersome, but it has the advantage of being web-based, whereas this is based on your desktop. But in either event, those types of applications combined with smartphones like the iPhone and the ability to post and read these messages, which you can actually put. There's an application for TweetDeck on the iPhone and on BlackBerry that you can use to monitor these multi-media feeds all at once. And the point is just twofold. One, it's a really interesting tool to actually use for those of you whose jobs have to do with the communication side of the administration of your court. And two, it's a clear demonstration that we're not just seeing discrete fads, which is what people often think of when they think of Twitter or Facebook. These aren't just discrete, sort of freestanding fads. They're all pieces of a larger picture, which amounts to a real pretty significant change in the way that people are sending and receiving information. Okay, so back to the research for a second. The Conference of Court Public Information Officers set out to take a in-depth look at this, and we identified 3 areas in our report where there are effects for courts from all these changes in new media. The first is effects in court proceedings. Second is effects on ethics and conduct for judges and court employees. And the third is effects on courts' ability to promote understanding and public trust and confidence in the judicial system. And just briefly on each of these, effects on court proceedings is the issue of jurors twittering, as I already talked about, members of the mainstream media wanting to tweet from the courtroom. These various ways that courts have already seen new media just sort of coming into the courtroom and having the potential to affect what goes on in a trial. And obviously when you're talking about that happening, that can be a scary thought, because there's nothing more important than the integrity of what goes on in a trial and making sure that due process is served and that problems aren't posed. And I'm sure many of you have seen some of the stories about there where problems have come up in this area. We deal with them in the report, and there's a lot of discussion about it on our website. So that's one of the things that we took a close look at, was what are the potential ways and actual ways that we're seeing effects from new media on court proceedings. The second is effects on ethics and conduct for judges and court employees. And there's a video that is on the website and that we show at some of these seminars. It has a slide in it that says what happens in Vegas stays on Facebook and Twitter and YouTube. And it's the idea that with all of this convergence that's going on and all of this multimedia social technology that's bringing people together and giving us greater access to images and video than we ever imagined, when somebody screws up, the potential for it to be colossally public is huge. And this has great potential effects for any employer. And if you're a court, in particular, we have a particular interest in supporting positive perceptions of the court. And so judges on Facebook, court employees even, excuse me, identifying themselves as court employees and going on Facebook and putting things on there that we might not like to see has some serious potential implications, and we examine those in the report. The third is a more positive area we looked at. The first two are kind of reactive and the third is more proactive. The first two are sort of potential problems that these technologies pose, and the third is the potential benefits that they might bring. So we looked at ways that courts might proactively go out and use some of this technology to support trust and confidence in the system. With the survey that we did, we ended up with the first national baseline data on these questions. We created the website that I already referred to. I talked about the survey that we did of judges, and we released the report in August. The point I wanted to make here is that this research is going to be ongoing, and we plan on doing a similar survey, hopefully on an annual basis, to look at how this stuff has changed moving forward. This is just a slide of the site that we created, which I really would encourage you to take a look at. There's a lot of information and resources there about new media, and it changes pretty regularly. I'm going to skip over this. This is just an examination of the specific categories of technology that we looked at. There's a lot more information about this in the report, which is available for download on the site. The big thing we're talking about is these social media profile sites, microblogging. When we say microblogging, we're talking about really Twitter, and there are other sites like Twitter, but the big one is Twitter. Smartphones like the iPhone. Monitoring metrics is a whole other category that I won't get into here, but has some potential impact on the courts. News categorizing, sharing, and syndication is RSS and other technologies that are allowing for rapid distribution of images, text, and other media through the web. Visual media sharing sites are like YouTube and Vimeo and Hulu that share video, but also some of the still image sharing sites like TweetDeck is a big one that, if you're not a Twitter user, you might not be familiar with, that people are using to share pictures through Twitter pretty effectively, and you're seeing that a lot. And finally, wikis are like Wikipedia or Judgepedia, which if you're not familiar with, I would suggest you take a look at, because if you might be surprised to see that your judges are on Judgepedia, and you might find things on there that aren't entirely accurate. So these are these open source technologies that allow for people to contribute to to a repository of information about particular topics. We found in looking at the at all these different topics that there were three broad areas where new media and the courts aren't exactly compatible in their cultures. I'll just touch on these briefly, but it's really something to take a look at and think about, that there's a reason that courts are among the very last to be embracing these technologies. That, as I said, well under 10% of courts that are using these as institutions. New media is a decentralized, multi-directional culture where anyone can contribute to the conversation. Courts are highly centralized, institutional, unidirectional in their nature, and there's an incompatibility there. New media are personal and intimate. On Facebook, you've got all these pictures of your really casual acquaintances that we now call friends on Facebook. There's an intimacy that's created there that people are becoming more and more comfortable with and used to, that's not exactly compatible with the way courts do business. And finally, courts are very text-based. We deal in the law, and we deal in the written word mostly, whereas new media is images and video and audio all brought together in a whole variety of different ways, and courts are going to have to the extent that we want to be connecting with the public, and I'm not talking about the actual proceedings of the court necessarily, but the business of trying to support understanding of the courts and connect with the public, courts are going to have to become more comfortable with multimedia technologies, because that's where everything's headed. So what should courts be doing in response to all this? Well, there's a lot that can be considered, but just a few things here to take a look at. Courts should probably be taking a look at their employee conduct policies and considering revisions to bring them up to date with the realities of new media and social media. there's always been restrictions on what court employees can say and do just in their general lives, and you know, one school of thought is that those just apply on Facebook, which they certainly would. But a lot of courts are already taking a look. I think California has done this. I think the federal judiciary is taking a look at this to just, you know, look at the way that current employee conduct policies are written and consider whether it would be productive to add provisions that specifically address social media. The same holds true for this second item here, revising jury instructions. This is a process that really is even farther along that a lot of courts are involved in. The federal courts have done this. The Ohio State Bar Association here in Ohio has done it in terms of model jury instructions that they have.